Miss Murphy, this is the letter that I'll be sending out to our client, Mr. Harris, along with the prepared documents upon your approval. I would like Mr. Harris to have the opportunity to look over each document before our scheduled meeting, as this should allow him more time to make notes of any clarifications needed. I included the type of documentation we drafted for the company. Number one you'll see is the charter for the state of Tennessee. I explained to him where we would be filing it and that the filing fee for that document is $100. The second document is the certificate of authority as a foreign corporation filed with the state of Arkansas, and the fee for that document is $300. And then we have the corporate bylaws for his company pursuant to the Tennessee statutes, which he will review and approve. And I also explained to him that we would be sitting down with him at our confirmed meeting to go over the documents in more detail and make any changes necessary for his approval and signature so we can get these documents filed for his corporation. This is our charter for profit corporation with the state of Tennessee, and I'm just going to go through this quickly. Everything's pretty cut and dry. On number one, I made sure to add incorporated after cutting edge computer repair to ensure compliance with TCA section 48-14-101 subsection A subsection 1. On number two, name consent, the business name was searched through the Tennessee Secretary of State website and no entity existed with the name Cutting Edge Computer Repair. Therefore, we didn't have to receive name consent from any other entity. Number three, the additional designation is a computer repair business. I just specified that for section 3. Number 4, our client, Mr. Harris, is listed as the registered agent with the business address as the appropriate location for service of process. The fiscal year close month I just left as a standard December, and the period of duration is perpetual. The corporation's for profit, the number of shares the corporation is authorized to issue is 10,000. And then again, I listed the complete address of the principal executive office. On the second page, we have, again, the name of the corporation. On number 10, I obviously didn't list the complete mailing address as it is the same as the address of the principal office. Number 11, I listed the names of both Bradley Stephen Harris with his home address, Cynthia Ann Lund with her home address, and number 12 kind of threw me off. It said since we entered in section 3 that it was a computer repair business, it would be required to list it as a professional corporation. However, I'm unsure if he is a licensed computer repair specialist. If he is, we need to ensure that we have that within his file in case that is ever questioned. If not, I do need to go back and edit section 3 to take out, let me scroll back up, to take out the additional designation of a computer repair business. And then of course we have the signature date, our client Mr. Harris's name, and then he would sign here once everything is complete and agreed upon. Since Mr. Harris is also wanting to do business in Arkansas, this is the certificate of authority, which you have to fill out if you're a foreign business only. This is separate from the certificate of authority for an Arkansas business. And it's pretty much the same. The name of the corporation is listed. The business name was searched through the Arkansas Secretary of State, so no fictitious name was needed to conduct business within the state of Arkansas. That's why B is left blank. On number 2, it's the same information from the previous. The state of Tennessee is where it was incorporated with the perpetual duration, and the date of incorporation I left at 7/31/19, which of course we can change when we know the actual date. The nature of the business is computer repair services. Number 4 is the place of business, which would be the main office in Memphis. And then we have the registered agent, which is Mr. Harris, with his address. And number 6 asks for the principal place of business, which is the Memphis address. It asks us to list the number and par value of any shares of the corporation's capital stock. So the number of shares is 1,000. The par value of the shares is none. Number 8, 9, and 10, I will explain with the client when he comes in to sign the documents. They're just explaining why the foreign corporation has to fill out the information, the filing fee, and that it's a crime to sign a false document for Secretary of State. And here is where Mr. Harris will sign. Now, in order to report the business tax information, we must also file the corporate franchise tax form, which I have right here. And it just asks for the company name, the contact person, which will be Bradley Harris since he is the registered agent, the telephone number, email address, and he's the authorized officer, so he would also have to sign here as well. And I think I missed, oh, also for the foreign corporation, the state of Arkansas also states that we must send the Secretary of State in their state our Tennessee charter, so that the Secretary of State in Arkansas can have those documents authorized before they will authorize this application to do business in their state. I have drafted the following bylaws for our client, Mr. Harris, and his corporation, Cutting Edge Computer Repair Incorporated, each article in accordance with the laws of the state. Part A, Article 1, concerns the corporate office. TCA Section 48-15-101, subsection A, subsection 1 requires that an office be maintained in the state of registration. The charter must also include the address, county, and zip code, as well as the initial registered office and head office. Although TCA Section 48-12-102, subsection A, subsection 3 states it's not essential to state the corporate office within the bylaws, it is prevalent to do so. So I just stated here that Cutting Edge's main office is in the charter, and everything was filed with the Secretary of State. So Article 2, I included that in accordance with TCA Section 48-15-104A, the registered agent and all information pertaining to the individual can be found within the charter. And then we have Part B, which is the shareholders, and Article 3 is the annual meeting. And TCA Section 48-57-101 covers a majority of the necessary additions regarding the annual meeting. So I'll go into more detail in the subsections here. Part A states that the annual meeting should be held at the location specified in the bylaws, although subsection B mentions the annual meeting held at the corporate office if not specified in the bylaws. I wanted to make the bylaws as concise as possible by adding the head office as the meeting place to curb any confusion. So in subsection B, we have the meeting date and time. And going back to the same statute, subsection A of that statute states the time and annual date must be specified within the bylaws. which is why the reason for including the specification of 9 a.m. meeting every second Monday of January is within the bylaws. Article 3C, I follow TCA section 48-17-105, which establishes notice requirements for corporations within the state of Tennessee. Subsection A also mandates notice provided to not be less than 10 days and no more than 2 months prior to the meeting. I provided 30 days of notice to ensure that everyone received the required notice by postal service or email, and I did not include the complete 2 months as the date is set annually, so all shareholders should expect their attendance to be required on that date each year. Now, subsection D is the notice waiver, and TCA section 48-17-106 sets the standard for the waiver of any formal notice within the corporation. Subsection A sets the requirement for written waivers, while subsection B permits waiver of a lack of notice or separate matter by objection at the beginning of the meeting that must be documented by the secretary to guarantee that all waivers are accounted for. Subsection E is proxy attendance, and that is governed by TCA section 48-17-203. Subsection A generally permits proxy voting, and I also included this provision within the bylaws. Subsection 1 specifies that the authorization must be in writing, which I also included in this article. I have clarified that an appointment is valid for 11 months as mandated by subsection 3. I also included the removal of an authorized proxy pursuant to subsection D 1 through 5. And subsection F is orders of business. And this article indicates what is to be discussed during the annual meetings, and that it is vital that the chairperson decides on any other subject matter discussed pursuant to TCA section 48-12-106B, which permits the chairperson to be more flexible in matters to be discussed at any stage. Article 3G necessitates a quorum of majority voting at annual meetings. Subsection C of TCA section 48-17-206 specifies the need for a majority vote to approve the action being voted on. And Article 3H enables the creation of a voting trust. Under TCA section 48-17-301 subsection A, each such action is permitted provided it includes more than one individual. Subsection B mandates no more than 10 years as a trust would be valid without signing an extended agreement. I also provided the option for an extension to be decided in the future as set out in subsection C. Section I prohibits cumulative voting, although TCA section 48-17-209 subsections A through C do permit cumulative voting as long as it's noted in the charter, but we chose not to include this as it was previously decided that a majority vote by the quorum would be adequate to make decisions for the corporation. J has to do it with no meeting. So TCA section 48-17-103 subsection A2 permits shareholders to submit a written request to the secretary of the corporation requesting a meeting if the annual meeting does not take place. I went a step further and added a provision allowing a court of competent jurisdiction to set a meeting date if it's not accomplished soon after the shareholder's written request has been submitted, which provided within the same statute. Article 4 has to do with special meetings, and it gives more detail regarding the conditions of TCA section 48-17-102. Subsection A1 enables the board to call special meetings. However, I also added a provision for the chairperson to also call special meetings to avoid any confusion. Subsection D limits the subjects of the meeting to those listed in the notice, which I also added to this article as it's relevant in preparation for a special meeting. Article 5 establishes the ground rules for telecommunication during meetings pursuant to TCA Section 48-17-109, which allows members to telecommute as long as they are able to participate in the meeting. The most significant aspect of this statute that I thought essential to add was that telecommuting is viewed the same as being present in person. Article 6 under Part C for directors relates to the director's authority. TCA Section 48-18-101A requires corporations to have a board of directors, whereas subsection B authorizes the board to properly manage the corporation's affairs. And Article 7 is mandated by TCA Section 48-18-103A, which requires the board to be composed of one or more directors. I have added to the bylaws that there must be a minimum of 1, but not more than 9, as this corporation is just beginning, and I wanted to offer them the ability to elect more if necessary when or if the corporation expands. However, I also added a clause pursuant to subsection B permitting more than 9 directors if it is deemed fit, and as it will make things easier for them to elect additional directors if necessary in the future. This article allows the corporation to do so without having to amend the bylaws. Article 8, here we are, has to do with the initial directors, and TCA Section 48-18-105A states that the term of the initial directors lasts until the first election. I also added that the initial directors were named in the charter so that there would be no confusion. Article 9 continues to apply the previous statute and explains the terms of the directors more effectively. I added more detail to the terms of the board utilizing subsection A again. I also found it important that this article should also have a provision for serving on the board for no longer than 3 years pursuant to subsection B. Article 10 has to do with compensation, and TCA Section 48-18-111 provides for fixed compensations for directors unless otherwise stated in the bylaws. Our client wanted this section to be worded in such a manner that there would be no loopholes, so I assisted him in drafting this article to prevent fixed wages, instead opting for travel, hotel, etc. compensation in terms of meetings, as their requirement is essential. This also provides an incentive to attend the meetings in person. Article 11 has to do with the quorum for the quorum for directors, which I previously touched on in regard to shareholders, and the same majority vote has been implicated here pursuant to TCA 48-18-205 subsection 1C. Article 12 gives the board the authority to hold additional meetings aside from the annual meetings as they see fit, and this article is in regard to TCA Section 48-108-201A. Article 13 relates to the duties of the board when holding special meetings. TCA Section 48-18-203 subsection B requires at least 2 days notice of these meetings, which has been added to this article. Also, TCA Section 48-18-201A enables the chairperson or any 2 directors to call meetings, which are also added to this article to establish more precise bylaws. Article 14 is a notice waiver for directors, again utilizing 48-18-204 and setting the same guidelines for directors, which allows shareholders to feel that they will be treated more equally by having the same rights and regulations. Article 15 is the directorial action without being required to hold a meeting. 48-18-202 subsections A through C set many requirements for directors and allowing decisions to be made in lieu of a meeting. This article includes provisions from the statute such as each director being required to be in agreement in writing, which allows the company to have documentation of the action. It must also be dated and delivered to the corporation immediately. Article 16 again is regarding telecommuting, but for directors, not shareholders. Again, pursuant to TCA Section 48-18-201B, I've set the same provisions for directors as I did shareholders. Telecommuting is permitted as long as they are able to participate in the meeting. Article 17 has to do with adverse interest on the part of the directors. TCA Section 48-58-704 is very precise in what needs to be done when a conflict of interest occurs. Pursuant to subsection B, the director must inform the secretary in writing, as well as any other qualified voters who may have a part in the director's adverse interests, and this prevents those with a conflict of interest from voting as not to have a vote that could be considered unethical. Article 18 sets the standard for board vacancies. According to TCA Section 48-18-110, subsection A2, the provision included in the bylaws enables the board to vote on who will fill the vacancy. Moreover, I included the substitute director to assume the role only until the next election. Article 19 is a provision for a removal of director. Statute 48-18-108A enables removal without cause. However, Mr. Harris would like the board to determine whether a mistake was made and enable the majority vote to rule as set out in subsection D. So we added that to the director removal section. Article 20 deals with the organization and procedure of meetings of directors. Mr. Harris was appointed chairperson pursuant to TCA Section 48-18-401B, and Ms. Lund was appointed secretary pursuant to subsection C. Also, subsection C specifies that there must be a secretary to record minutes and other responsibilities, which is another reason why Ms. Lund was added here. Her proper job description has been added to cover subsection D, which states that one individual can hold more than one position. Article 21 is in place regarding director committees. TCA Section 48-18-206 subsection A allows directors to form committees unless bylaws state otherwise. Another statute I used to draft this article is 48-18-401, which will be referred back to in Article 22 and 23. Part D regards the officers, and Article 22 follows the previously noted statute and is just a general overview of the initial positions placed within the bylaws. Article 23 goes into more detail regarding the allowances of TCA Section 48-18-401. Subsection A states officers must be described, and I have included the chairperson and secretary positions along with the duties expected of both positions to comply with the statute. I also included the minutes documented during meetings, the secretary's job duties to comply with subsection C. Since the corporation is just beginning, Ms. Lund feels she can cover both the roles of secretary and treasurer. However, a stipulation has been added that if in the future a treasurer will be elected to assume accountability. Article 24 is about the term, and TCA Section 48-18-105 subsection B states the length of the terms allowed, at least one and no more than 3 years, which is what this article reflects. Article 25 has to do with resignation, and subsection A of TCA Section 48-18-107 requires resignation to be by written notice, and subsection B determines that the date the notice is delivered is the date that the resignation is actually valid, which is put into place by this article. Financial affairs and monetary instruments is Article 26, and TCA Section 48-16-401, subsection A, permits the board to make monetary distributions to shareholders, while subsection C 1 through 2 specifies when no distribution can be made, and included within this article are provisions that meet all previously stated subsections in more detail to ensure that this article follows the proper statute. Part F is just part of the general provisions added for future use. Article 27 is in regard to amendment of the bylaws. TCA Section 48-20-201B allows both the board and the shareholders to amend the bylaws, and Section A states that it must occur through a vote, and that the shareholders can also decide whether any of the bylaws cannot be amended by the board. This is important to include if the shareholders and board are not in agreement, but also giving both equal power. Article 28 was included in regard to indemnification. TCA Section 48-12-1023A 1 through 3 limits liability on individuals in terms of legal action taken against the company as a whole for particular acts. This article allows for directors and board members to be reimbursed for litigation that was due to an act of good faith or an act that was not knowingly committed in bad faith. Article 29 restates the previously decided option to change the fiscal year if needed. However, the important information within this article is in regard to TCA Section 48-26-203 subsection C, which states the requirements for filing reports with the Secretary of State, and I have included that 4-month provision within this article. Article 30 lays out how dissolution may be acquired, the necessary documents that must be filed, and the written notice required in the case of dissolution of the company. I have included all provisions that go with TCA Section 48-24-103 within this article, and what must be done to dissolve the company. And I also put the statute within the bylaws, so if it happens years down the road, they can actually go back to the statute and see if it's been edited, or see if a new statute is in place, and that way everything is legal on their end.